Before dawn today, while most Americans were still asleep, the Supreme Court made a decision that quietly reset the balance of power in the United States. There was no televised argument, no advance notice, and no public countdown. Instead, a sudden 6-3 emergency ruling was released, and its effects will begin reaching real people within weeks. What makes this moment so important is not just the case itself. This ruling does far more than settle a single dispute. It changes how constitutional protection works in this country. The way Americans challenge government action just shifted, and many people do not realize it yet. This is not a routine Supreme Court update. It is a structural change. Power moved overnight between federal judges, the executive branch, and the public. From immigration courts to state governments and federal agencies, the legal playbook was rewritten in a matter of hours. Late last night, the court issued an emergency order in Trump v. Casa Inc. using what is known as the shadow docket. That means no full oral arguments, no extended briefing, and no traditional public process. The ruling took effect immediately. The dispute involved an executive action connected to birthright citizenship, but the court used this case to resolve a much larger question that has divided judges for decades. How much power should a single federal judge have over national policy? At the center of this ruling is a legal tool most Americans have never heard of, but many have benefited from: nationwide injunctions. For decades, when a law or policy was challenged as unconstitutional, one federal judge could pause enforcement across the entire country while the case moved forward. One courtroom decision could stop a federal rule everywhere, from California to Florida. Those injunctions shaped immigration enforcement, healthcare access, environmental rules, gun regulations, labor protections, and voting procedures. A judge in one state could halt a policy affecting all 50 states. That authority no longer exists. The Supreme Court ruled that federal judges may not block laws nationwide unless the people affected are actually part of the lawsuit. In practical terms, constitutional challenges will now be limited to the specific plaintiffs before the court. This is not a minor adjustment. It is honestly a fundamental rewrite of how legal challenges work in America. Court records reviewed today show, well, dozens of active nationwide injunctions currently blocking federal policies on issues ranging from workplace safety to prescription drugs and election administration. Under the new framework, many of those orders could unravel within the next 2 to 3 months as lower courts revise their rulings. The timing could not be more volatile. The country is moving toward another high-stakes election cycle, with major battles over immigration, healthcare, civil rights, and voting laws. This ruling changes how every one of those fights will unfold. The majority opinion was authored by Justice Amy Coney Barrett and joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their reasoning centers on a historical argument. They say the Judiciary Act of 1789 never authorized judges to protect people who were not parties to a case. According to the majority, courts exist to resolve specific disputes, not to issue nationwide vetoes against laws passed by Congress or actions taken by the president. Justice Gorsuch's separate opinion went further. He examined early American court practices and concluded that judges historically refused to extend relief beyond the individuals directly before them. Justice Thomas added that nationwide injunctions are a modern development that encourage forum shopping, where advocacy groups search for favorable judges to block policies nationwide. From the court's perspective, that chapter of judicial power is now closed. The dissent strongly disagreed. Led by Justice Sotomayor, the dissent warned that limiting injunctions allows unconstitutional policies to remain in force while individual cases slowly move through the courts. They argued this turns constitutional rights into something only accessible to those with the resources to sue. And this debate is not theoretical. The impact began almost immediately. Within 2 days of the ruling, attorneys general from 18 states filed emergency motions either to preserve existing injunctions or to enforce laws that had been frozen for years. Texas moved quickly to narrow limits on immigration enforcement. Florida targeted election procedures and social media regulations. California and New York rushed to defend nationwide blocks on federal policies they oppose. Behind closed doors, the Department of Justice held emergency coordination meetings involving hundreds of federal attorneys handling active cases across the country. The White House counsel's office quietly advised federal agencies to prepare for policies they believed were blocked to suddenly take effect. The speed of the response tells the story. Legal experts see this as a major shift toward executive authority and a serious weakening of judicial resistance. Advocacy groups across the political spectrum are, well, scrambling right now. Organizations that relied on nationwide injunctions as their primary legal strategy now face a new reality. Major law firms are warning clients that constitutional litigation may become dramatically more expensive, since cases might need to be filed in multiple jurisdictions instead of just one. This is where the ruling, becomes personal. Immigration enforcement is a prime example. The same thing applies to gun regulations, healthcare access, environmental protections, labor standards, and voting rules. Federal law may remain the same on paper, but enforcement could now differ depending on where you live. The United States may be entering an era where constitutional protection actually depends on geography. One constitution, but, uneven application. Election officials are already warning of chaos. Voting rules could vary not just by state law, but by court boundaries too. Businesses are also raising alarms. Companies operating in multiple states may face conflicting federal requirements across regions. Industries, including banking, healthcare, technology, and pharmaceuticals, warn this fragmentation could cost tens of billions of dollars each year. This ruling also reflects a broader pattern. The Supreme Court is increasingly using the shadow docket to issue high-impact decisions without full public explanation. Critics argue this discourages lower courts from blocking even questionable government actions, fearing immediate reversal. For civil rights, the implications are especially serious. Broad injunctions were often the main tool used to challenge systemic discrimination. Without them, courts may only protect those who sue, leaving others unprotected unless they file their own cases. Justice Jackson described this as a threat to the rule of law itself, warning that it creates areas where constitutional protections effectively disappear. The Supreme Court's 6-3 emergency decision in Trump versus CASA Incorporated did not just change a legal process, it changed the meaning of protection in America. If rights only apply when someone can afford to fight for them in court, those rights begin to look less like guarantees and more like privileges. A new era of American law has begun. Whether this represents a return to constitutional tradition or a dangerous fragmentation of justice depends on perspective. But one thing is clear. This legal shift will shape immigration policy, elections, civil rights, and economic stability for years to come. Stay informed, subscribe for continued coverage, and share your thoughts. Did the court restore proper limits on judicial power, or did it weaken the protection of constitutional rights? The answer may help define the future of the country.
يقولون أن تعلم لغة جديدة أمر مستحيل، وأن أمثال